White judge finds, black woman only to learn she's a federal prosecutor. Sarah Collins had planned her morning meticulously. As an assistant United States attorney for the Northern District of Georgia, precision was not just a professional asset, it was a daily necessity. Her schedule that Thursday had been arranged with surgical precision, a quick 8:30 a.m. appearance at municipal court to dispute a parking ticket, followed by a 10:00 a.m. meeting with her trial team for the Donovan case, a major human trafficking prosecution that had consumed her professional life for the past 11 months. She'd selected her attire deliberately, a charcoal pantsuit that was professional but not ostentatious with minimal jewelry, and her natural hair styled in a neat twist. After 8 years as a federal prosecutor, Sarah had learned that her appearance in court was subject to scrutiny. Her white male colleagues never experienced too formal, and she'd be labeled unapproachable, too casual, and her credibility would be questioned. At 7:45 a.m., she placed her badge and credentials in her briefcase alongside the photographs and documentation, proving that the parking sign had been obscured by construction equipment on the day she received the citation. It was a minor matter, a $75 ticket, but it was the principle that mattered. The justice system relied on accuracy even in the smallest matters. Sarah was halfway to her car when her phone rang. The screen displayed Marcus Wilson, her immediate supervisor and the chief of the criminal division, Collins. She answered, maintaining her brisk pace toward the parking garage. "Sarah, we've got a situation with Donovan." Marcus said, without preamble, "ICE just picked up 3 new witnesses who may have been trafficked by his organization. They're being held at the detention center, and we need someone there immediately for preliminary interviews before defense gets wind of them." Sarah stopped walking. "Marcus, I have a court appearance this morning. I know your schedule, Collins, but this can't wait. Judge Hernandez granted our motion to delay jury selection until Monday, but that only gives us today and tomorrow to prep these witnesses. If they're viable. Reed is down with the flu, and Henderson is in DC for that conference." Sarah glanced at her watch. 7:52 a.m. "I can head to the detention center after my municipal court appearance." "These witnesses are scared and talking now. In 3 hours, they might shut down completely. You're lead prosecutor on Donovan. They need to hear from you that cooperation means protection." She closed her eyes briefly, calculating. Her court appearance was in the downtown traffic court at 8:30. The detention center was a 30-minute drive in the opposite direction. Even if she rushed the witness interviews. "I'll handle it," she decided, "but I'll need someone to request a continuance on my traffic hearing." For a parking ticket, Marcus sounded incredulous. "Just pay it online and be done with it." "Collins, this is a major human trafficking case." The sign was obscured. "Marcus, it's the principle of email the documentation to the clerk and reschedule." He interrupted. "The Donovan case has to take priority, and you know it." She knew he was right. Professionally speaking, the Donovan case represented months of work and affected dozens of victims. Compared to that, her parking ticket dispute was trivial, but the principle wasn't trivial. A mistaken citation should be corrected, not paid for convenience. "I'll head to the detention center now." She conceded, "Have Tanya send the case files to my tablet." As she redirected her steps, Sarah pulled up the municipal court's website on her phone, looking for an option to request a continuance online. To her frustration, the system required such requests to be made at least 48 hours in advance. She attempted to call the clerk's office, but at 8:20 a.m., it hadn't opened yet. For the next 2 hours, Sarah focused entirely on the traumatized witnesses at the detention center. Their testimonies were harrowing, but crucial, potentially enough to close the remaining gaps in the prosecution's case against Anton Donovan. By the time she had conducted preliminary interviews, arranged for victim services, and coordinated with the federal marshals for witness protection assessments, it was nearly 10:30 a.m. As she walked back to her car, the missed court appearance crashed back into her awareness. She checked her phone to find a notification from the municipal court's automated system. "Failure to appear for hearing, T27845. New fine 175, appearance required within 72 hours. The fine had more than doubled, and now she was required to appear in person to address it. Sarah felt a flicker of irritation, not at the system itself, which was just following protocol, but at the circumstance that had forced her to choose between her professional responsibilities and her personal ones. She dialed the clerk's office, which was now open, and explained her situation. The clerk was sympathetic, but firm. "The court schedule for today is full, Ms. Collins. Judge Barrett doesn't accept retroactive excuses for missed appearances. You'll need to come in person to address the increased fine and prevent a further penalty." Sarah checked her calendar. The afternoon was packed with Donovan case preparation, but there was a window at 2:30 p.m. when her team would be reviewing forensic evidence without her direct involvement. "I can be there at 2:30, she said. "I'll note that on the docket," the clerk replied. "But I should warn you, Judge Barrett can be particular about tardiness and rescheduling. You might want to bring your documentation about the obscured sign." "I will," Sarah assured her, already mentally adjusting her day's timeline. "Thank you." As she drove back to the federal building, Sarah tried to shake off a nagging sense of unease. She had appeared before dozens of judges throughout her career from municipal court to the 11th Circuit. She had argued complex federal cases before panels of stern-faced appellate judges without a tremor in her voice. A simple parking ticket dispute should be trivial. Yet something about the clerk's warning lingered in her mind. There was an undercurrent to the words, "Judge Barrett can be particular," that suggested complications beyond the usual judicial temperament. She made a mental note to be exceptionally prepared, even for this minor matter. The next 4 hours disappeared in a flurry of case preparation team meetings and rapid-fire decisions about the Donovan prosecution. By 2:15 p.m., Sarah was gathering her documentation for the municipal court appearance, now acutely aware that she was likely to be a few minutes late for the 2:30 p.m. slot. She called the clerk's office again. "This is Assistant U.S. Attorney Sarah Collins. I have a 2:30 appearance, but I'm running about 10 minutes behind. Can you please inform the court?" "I'll make a note, Ms. Collins, but I should tell you that Judge Barrett starts his afternoon calendar promptly at 2:30. Being late, well, it doesn't make a good impression." "I understand," Sarah replied, already heading for the elevator. "Please let the court know I'm on my way." As she navigated downtown Atlanta traffic, Sarah couldn't help but reflect on the irony of her situation. She normally stood before the court, representing the full authority of the United States government. Today, she was just another citizen with a disputed parking ticket running late for an appointment with a reportedly strict municipal judge. She had no way of knowing that this seemingly minor court appearance would become one of the most consequential of her career, for reasons that had nothing to do with a parking sign or a $175 fine. Municipal Courtroom 3B was housed in a building that stood in stark contrast to the federal courthouse where Sarah normally practiced. Where the federal building projected the gravitas of marble columns and soaring ceilings, the municipal court occupied a utilitarian structure with fluorescent lighting and linoleum floors that had seen better days. Sarah hurried through security badge and ID ready, but the security officers processed her like any other citizen, her federal credentials irrelevant to their municipal domain. The wall clock read 2:43 p.m. as she pushed through the double doors into Courtroom 3B. The scene that greeted her was familiar to anyone who had experienced traffic: court rows of uncomfortable wooden benches filled with a cross-section of Atlanta's population, all waiting their turn before the bench. Judge William Barrett presided from a raised platform, his expression suggesting he'd rather be anywhere else. At 62, Barrett had the weathered countenance of someone who had seen it all and been unimpressed by most of it. His steel grey hair was perfectly combed, his robes immaculate. He had been a fixture in the municipal court system for nearly 15 years, having transitioned to the bench after a moderately successful career in private practice. As Sarah slipped into the courtroom, Barrett was addressing a young white man in a rumpled suit who had apparently also arrived late for his hearing. "Mr. Donaldson, while I don't appreciate tardiness, I understand that traffic on I-85 can be unpredictable. Your fine remains at the original $60, but please make an effort to be punctual in the future. The clerk, a middle-aged woman with an efficient demeanor, noticed Sarah's entrance and made a notation in her system. Your Honor, we have Ms. Sarah Collins here for case T27845, originally scheduled for 8:30 this morning, rescheduled for 2:30 p.m. Judge Barrett glanced at the clock, then at Sarah, his gaze sharpening as he took in her appearance. She felt a familiar sensation being assessed and categorized in the space of a heartbeat. Assumptions made based on the color of her skin rather than the content of her character, Ms. Collins. Barrett's voice carried the particular inflection of someone addressing a child or subordinate. You were scheduled to appear at 8:30 a.m., failed to do so, were granted the courtesy of a rescheduled hearing for 2:30 p.m., and have now arrived at 2:43 p.m. Would you care to explain your apparent difficulty with punctuality? Sarah approached the podium, maintaining the professional composure that had served her through countless high-pressure situations. Good afternoon, Your Honor. I apologize for my tardiness. This morning, I was called to the Federal Detention Center for emergency witness interviews in a human trafficking case. I attempted to contact the court before my scheduled appearance. Ms. Collins, Barrett interrupted. This court handles hundreds of cases daily. Each citizen who appears before me believes their situation is uniquely important or deserving of special consideration. The businessman has meetings, the student has exams, the mother has childcare constraints. Yet somehow most manage to appear at their scheduled time. Sarah attempted to continue her explanation. Your Honor, I'm not seeking special treatment. I'm simply explaining that as an assistant United States attorney, I was required to. The judge's eyebrows rose a flicker of surprise, quickly replaced by something harder to define. You're claiming to be a federal prosecutor. I am a federal prosecutor. Your Honor. Sarah reached for her credentials. I can provide identification if the court wishes. That won't be necessary, Barrett said dismissively. Your occupation, whatever it may be, doesn't exempt you from following the same rules as everyone else in this courtroom. You missed your original hearing and have now arrived late for your rescheduled appearance. Your fine is increased to $250, due within 7 days. Sarah felt a flash of disbelief. The original $75 ticket had already been increased to $170 for missing the morning hearing. An increase she had accepted as the standard penalty, but this additional $75 for being 13 minutes late seemed disproportionate, especially given the leniency shown to the previous defendant. Your Honor, with respect, the defendant before me was also late for his appearance, yet his fine remained at the original amount. Barrett's expression hardened. Mrs. Collins, are you questioning this court's authority to administer appropriate penalties? Mr. Donaldson was 7 minutes late and offered a reasonable explanation. You missed your entire morning hearing and arrived 13 minutes late this afternoon. The situations are not comparable. Sarah remained outwardly composed, but her prosecutor's mind was cataloging every detail of the interaction, the contrasting treatment, the dismissive tone, the immediate skepticism about her professional identity. She had experienced subtle bias throughout her career, but rarely had it been so blatant, especially in a court of law. I understand, Your Honor. However, I would like to address the substance of my case. I believe the ticket was issued in error as the parking signage was obscured by construction equipment. On the day in question, I have photographic evidence. And Ms. Collins. Barrett cut her off again. You forfeited your right to contest the ticket when you failed to appear at your scheduled hearing this morning. The only matter before this court now is your payment of the $250 fine. Will you be paying that today? Or do you need the 7-day grace period? The courtroom had grown unusually quiet. The gallery, normally distracted and restless during traffic proceedings, seemed to sense the tension building between the black woman at the podium and the white judge on the bench. Sarah made a split-second decision. Your Honor, before I answer that question, I would like to note for the record that I am formally documenting what appears to be disparate treatment in your courtroom. Barrett's face flushed. Excuse me. In the interest of justice and transparency, I am noting that you accepted the tardiness explanation from Mr. Donaldson, a white male, without question, and maintained his original fine. You then dismissed my explanation as a black female and increased my fine significantly. I am also noting your skepticism regarding my professional identity, which would have been simple to verify rather than dismiss. The judge's knuckles whitened as he gripped the edge of the bench. Ms. Collins, you are bordering on contempt of court. Sarah reached into her briefcase and withdrew her federal credentials, holding them up so they were clearly visible to both the judge and the now riveted gallery. I am Assistant United States Attorney Sarah Collins of the Northern District of Georgia. In that capacity, I am ethically obligated to report potential civil rights violations, including disparate treatment based on race or gender in our justice system. A stunned silence fell over the courtroom. Judge Barrett stared at the credentials, the federal seal and Department of Justice identification, clearly visible even from his position on the bench. For perhaps the first time in his 15 years on the municipal court, William Barrett appeared genuinely unsettled. Your Honor, Sarah continued, her voice calm, but carrying an unmistakable note of authority. I will pay the $250 fine today under protest. However, I am formally requesting the court records from today's proceedings, as well as a random sampling of case records from the past 6 months, to evaluate whether this disparate treatment is an isolated incident or part of a pattern that warrants further investigation. The clerk looked uncertainly between the judge and the federal prosecutor, clearly unsure whose authority took precedence in this unprecedented situation. Several spectators had taken out their phones. Though the court's no recording policy prevented them from documenting the confrontation directly. Judge Barrett seemed to realize that the dynamic in his courtroom had fundamentally shifted. His authority, usually absolute within these walls, was suddenly balanced against that of a federal officer raising serious concerns about his conduct. Morse. Collins, he said, finally his tone moderated. If you have concerns about court procedures, there are appropriate channels through which to address them. Making accusations in open court is not one of them. On the contrary, Your Honor, Sarah replied, transparency in our judicial proceedings is fundamental to maintaining public trust. The appropriate time to address apparent bias is when it occurs. She paused, then added, I'm sure you agree that our justice system must not only be fair, but must also appear fair to those it serves. Barrett recognized the trap in her statement. Disagreeing would only validate her concerns about his impartiality. He cleared his throat. This court has always strived to administer justice equitably. If you believe otherwise, you are certainly entitled to pursue any review you deem necessary. Now regarding your fine, I'll pay it immediately. Sarah interrupted gently, a subtle reminder that the power dynamic had shifted. And I'll submit my formal records request to the clerk before I leave. Thank you for your time, Your Honor. With that, she gathered her documents and turned to leave the podium. As she walked back through the gallery, she felt dozens of eyes following her, some with surprise, others with what appeared to be newfound respect or even admiration. Behind her, Judge Barrett called the next case, his voice lacking the confident authority it had carried just minutes earlier. What had begun as a routine traffic matter had transformed into something far more significant. A confrontation that would have repercussions well beyond courtroom 3B. Word of the confrontation between AUSA Collins and Judge Barrett spread through Atlanta's legal community with remarkable speed. By the time Sarah returned to her office at the federal building, her phone was already filling with text messages from colleagues who had heard varying versions of the encounter. Marcus Wilson was waiting in her office, his expression a mixture of concern and curiosity. So I hear you decided to turn a parking ticket into a civil rights case, he said, closing the door behind him. Sarah set her briefcase down, suddenly aware of how tense her shoulders had become. News travels fast. The law clerk for Judge Rivera was in that courtroom visiting his girlfriend, who works in records. He called Rivera, who called me. Marcus leaned against her desk. What happened, Sarah? She recounted the interaction in precise detail, her prosecutor's memory capturing the exact wording of Judge Barrett's statements, the contrasting treatment of the cases, and her decision to formally challenge the disparity. Marcus listened without interruption, his expression growing more serious as she spoke. When she finished, he let out a low whistle. Barrett's been on that bench for 15 years? Never heard of anyone calling him out like that. Someone should have. Sarah replied, "That kind of disparate treatment doesn't develop overnight. I'm willing to bet a review of his case records would show a clear pattern." "You're probably right," Marcus acknowledged. "But you've potentially kicked a hornet's nest here. Barrett has connections in the legal community, friends in the state judiciary." Sarah met his gaze directly. "Are you suggesting I should have stayed quiet? Accepted the disparate treatment because challenging it might be professionally uncomfortable?" Marcus raised his hands in a placating gesture. "Not at all. I'm just saying there might be blowback, and I want you prepared for it." He paused, then added, "For what it's worth, I think you did exactly what anyone in your position should have done. I'm just not sure everyone would have had the courage." The following morning, Sarah submitted a formal request for Judge Barrett's case records to the municipal court clerk's office. By noon, the request had been flagged to the attention of the presiding judge of the municipal court, Elena Vasquez, who requested an immediate meeting with Sarah. Judge Vasquez's office reflected her 15 years on the bench and her reputation for meticulous attention to detail. Every law book was precisely aligned. Every file neatly labeled. The judge herself, a woman in her early 60s, with silver-streaked black hair, regarded Sarah with a measured gaze as she entered. "AUSA Collins. Thank you for coming on such short notice." She began gesturing to the chair across from her desk. "I understand you had an interesting experience in Judge Barrett's courtroom yesterday." "That's one way to describe it." "Your Honor," Sarah replied, maintaining the professional courtesy appropriate when addressing a judge even in an informal setting. "I've reviewed the preliminary transcript," Vasquez continued. "Before we go further, I want to be clear. Are you planning to file a formal complaint against Judge Barrett with the Judicial Qualifications Commission?" Sarah had considered this question carefully since the previous afternoon. A formal complaint could trigger an investigation into Barrett's conduct, but it would also potentially escalate the situation into a protracted legal battle that might overshadow the underlying issue. "My immediate concern isn't punitive action against Judge Barrett," she explained. "It's determining whether there's a systemic issue of disparate treatment in his courtroom. That's why I requested the case records to evaluate whether what I experienced was an isolated incident or part of a pattern." Vasquez studied her for a moment. "A data-driven approach. I appreciate that." She tapped a folder on her desk. "What would you say if I told you that I've had similar concerns about Judge Barrett's courtroom for some time, but lacked the hard evidence needed to take action?" Sarah's interest sharpened. "I'd say that makes the records review even more important." The presiding judge nodded. "I agree, which is why I've already instructed the clerk's office to prioritize your request. However, I wanted to propose a more comprehensive approach." She opened the folder and slid a document across the desk. "This is a draft administrative order authorizing a full review of sentencing patterns across all municipal courtrooms with particular attention to potential disparities based on race, gender, and socio-economic factors." Sarah scanned the document, impressed by its scope and the clear methodology it outlined. "This goes well beyond my request. Because your request highlighted a concern I've had for years," Vasquez admitted. "We all took an oath to administer justice fairly, without prejudice or bias. If that oath is being broken by Judge Barrett or anyone else, I want to know, and I want it addressed." "I fully support this approach," Sarah said, feeling a cautious optimism. "But may I ask why you're consulting me about an administrative matter within the municipal court system?" Vasquez's lips curved in a slight smile. "3 reasons. First, your request initiated this process, so you deserve to know how it's being handled. Second, your perspective as both a federal prosecutor and someone who experienced potential bias firsthand is valuable. And third, frankly, having the support of the US Attorney's Office would insulate this review from potential political pushback. Sarah considered this. I can't officially speak for the US Attorney's Office in this matter without consultation, but I can say that addressing potential bias in our justice system aligns perfectly with our mandate to ensure equal justice under law. That's all I'm asking for at this stage, Vasquez assured her. A preliminary review will take about 2 weeks. If it confirms our concerns, then we can discuss next steps, including whether formal involvement from your office would be appropriate. As Sarah left the meeting, she felt a sense of guarded optimism. What had begun as a personal confrontation was evolving into something potentially transformative, a systematic examination of bias in a court system that affected thousands of Atlanta citizens daily. Her phone buzzed with a text from Marcus, Channel 11 requesting comment on courtroom confrontation with biased judge. How do you want to handle? Sarah sighed. The media attention was inevitable, she supposed, but not particularly helpful at this stage. No comment while review is ongoing. She texted back, "Will explain when I get back to the office." By the time she reached her car, another text had arrived, this one from an unknown number. "Thank you for standing up in that courtroom yesterday. You inspired a lot of people who usually feel powerless in the system." A regular citizen from the gallery. Sarah sat in her car for a moment, rereading the message. Throughout her career as a prosecutor, she had focused on the big cases, the trafficking networks, the corruption schemes, the major drug operations. It was easy to forget that justice also happened in small courtrooms over minor infractions where citizens formed their most direct impressions of the legal system. Perhaps that was where it mattered most of all. The findings of Judge Vasquez's comprehensive review were released 6 weeks later, and they confirmed what Sarah had suspected from her single interaction with Judge Barrett. The data revealed clear disparities in how different demographic groups were treated in his courtroom. Black defendants were 7 times more likely to receive maximum fines than white defendants for identical violations. Women of color faced the highest rate of interruption during their statements to the court. Leniency for tardiness or missed appearances was granted disproportionately to white male defendants. Extension requests for payment were denied at significantly higher rates for minority defendants. Most damning was the pattern of skepticism toward professional credentials, precisely what Sarah had. Experienced black attorneys. Particularly, women were routinely asked to verify their bar status or professional affiliations while their white counterparts were taken at their word. The review hadn't stopped with Judge Barrett. It had examined patterns across all municipal courtrooms, finding varying degrees of disparity, but nothing as pronounced as in courtroom 3B. The results were presented at a closed-door meeting of the municipal court judges with representatives from the State Bar Association and the Judicial Qualifications Commission. Present Sarah, as the catalyst for the investigation, was invited to attend, but chose to send Marcus Wilson in her place, feeling that her presence might make the discussion more about her personal experience than the systemic issues identified. Judge Barrett was offered the opportunity to review the findings before they became public. 3 days later, he submitted his resignation citing personal reasons and a desire to spend more time with family. The standard euphemism for a career ended under a cloud. While the full report remained confidential, a summary of its findings and recommendations was released to the public, prompting a wave of media coverage and community discussion. For Sarah, the outcome was satisfying but bittersweet. A biased judge had been removed from the bench, but she took no pleasure in ending someone's career. What mattered was the broader impact. The municipal court had implemented a series of reforms in response to the findings. 1. Mandatory bias training for all judges and court personnel. 2. A new system for tracking and reviewing sentencing patterns to identify potential disparities. 3. A citizen review panel to provide community oversight of municipal court practices. 4. Clear protocols for handling complaints about judicial conduct. Sarah had declined most interview requests, preferring to let the reforms speak for themselves. but she had agreed to speak at a community forum organized by the Atlanta Bar Association focused on addressing bias in the justice system. The event was held at a community center in a predominantly black neighborhood, drawing a diverse audience of legal professionals, community activists, and ordinary citizens. As Sarah approached the podium, she was struck by the sight of several familiar faces in the audience, people who had been in courtroom 3B the day of her confrontation with Judge Barrett. 6 weeks ago, she began. I went to traffic court for a parking ticket, probably the least significant legal matter I've handled in my entire career. Yet that experience has proven to be one of the most consequential, not because of what happened to me personally, but because it highlighted something many people in this room already knew. Justice isn't always blind. She paused, looking out at the attentive faces before her. As prosecutors, judges, and officers of the court, we wield enormous power over people's lives. Sometimes in ways we don't even recognize. A dismissive tone, an interrupted explanation, an assumption made based on appearance. These seemingly small things can communicate to citizens that the system doesn't value them equally. She continued describing how the data had confirmed what many had experienced anecdotally for years. The patterns revealed weren't about explicit bigotry. Judge Barrett would likely deny harboring any consciously racist or sexist views. The data showed something more insidious. Implicit bias operating day after day, case after case, creating disparate outcomes that became normalized within the system. Toward the end of her address, Sarah shared something she hadn't spoken about publicly before. The morning after my confrontation with Judge Barrett, I received a text message from someone who had been in that courtroom. It read, "Thank you for standing up. You inspired a lot of people who usually feel powerless in the system." She looked around the room, making eye contact with as many people as possible. That message reminded me of something essential about our justice system. It doesn't belong to judges or lawyers or prosecutors. It belongs to all of us. And it only works when everyone, regardless of race, gender, or economic status, can walk into a courtroom confident that they will be treated with equal dignity and respect under the law. The applause that followed was enthusiastic, but what meant more to Sarah were the conversations that happened afterward. One woman approached her with tears in her eyes, describing how she had paid unfair fines for years because she didn't believe she had the right to challenge them. A young black law student asked for advice about maintaining her integrity in a system where she might face similar bias. A municipal court clerk thanked her for initiating changes they had wanted for years, but lacked the leverage to demand. As the event wound down, Sarah found herself speaking with Judge Vasquez, who had attended quietly from the back row. "You've started something important," the judge told her. "Barrett's resignation is just the beginning. The conversation is happening in courthouses across the state now." "Do you think it will lead to real change?" Sarah asked. Vasquez considered this. Systems resist change, especially when it requires people to examine their own biases. "But yes, I do. Because you did something rare. You used your privilege and position to address an injustice that wasn't directly threatening your case or your client. You made it about the principle, not the parking ticket." Later that evening, as Sarah drove home, she reflected on the strange journey that had begun with a partially obscured parking sign. Her original fine, the $250 she had paid under protest, had been refunded as part of the court's corrective actions. She had donated it to a legal aid organization that helped low-income citizens navigate the municipal court system. The Donovan human trafficking case, which had caused her to miss her original court appearance, had resulted in a conviction on all counts the previous week. It was one of the most significant victories of her career yet. Somehow the parking ticket dispute felt equally meaningful, a reminder that justice mattered at every level, from the highest federal court to the most routine municipal hearing. As she pulled into her driveway, Sarah's phone lit up with a notification. It was an email from the municipal court clerk's office with the subject line, "Implementation of Collins Protocol for Bias Monitoring." She smiled at the unexpected recognition. The so-called Collins Protocol was the data tracking system designed to identify patterns of disparate treatment before they became entrenched. That her name had become attached to it seemed fitting a reminder that sometimes standing up in the right place at the right time could ripple outward in ways you never anticipated. The parking ticket that had started it all remained on her desk at work, framed alongside a simple quote from Justice Thurgood Marshall. In recognizing the humanity of our fellow beings, we pay ourselves the highest tribute. It served as a daily reminder that justice wasn't just found in landmark Supreme Court decisions or high-profile federal prosecutions. Sometimes it began with a single person refusing to accept unfairness, even in the smallest of matters, especially in the smallest of matters, where the true character of our legal system was revealed every day.